We need not to say anything about the chief guest of this seminar. The whole hall is vibrating with his prominence. He started his career as a lawyer in 1989. He conducted more than 1,000 cases, including many reported judgments, during 20 years standing in profession at bar. He served our legal community as a teacher as well. He taught in PULC, Punjab University Law College, for 12 years and many other private law colleges for 18 years. He remained internal and external examiner at Punjab University for a long time, and his list of achievements is very long. He is the light of guidance for the professionals. Here we welcome Mr. Justice Ali Baqar Najafi. Standing ovation, please.
Please. Yes. Mr. Punnu Sahab, President Lahore High Court Bar Association, Mr. Hassan Varais Sahab, the Secretary, Lahore High Court Bar Association, Mr. Haseeb Khan, the Chairman of the Legal Education Committee of the High Court Bar Association, distinguished guests, members of the fraternity, Assalamu alaikum. Normally it is said that the judges only speak through their judgments. But at times, they have to appear before an august gathering like present one and to speak their heart out. Language has always been a weak medium of communication. And I must admit that a judgment to a judge is even weaker expression of his opinion. Our profession is very serious by its nature, but at times we have to, improve ourselves and give it a little break. Make it a more attractive and more acceptable profession with a good and pleasant feelings exchange with each other. I must congratulate Mr. Haseeb Khan for conducting these kind of lectures for the last many, many years, and I have always been privileged and honored by his and his team when they have invited me on more than once to speak on the given topics. As a continuation of the said practice, today I am before you, and I have been asked to say something about NAB laws and trials. Normally, you all, my friends, the London members of the bar, you appear before my court and our court, and you argue your case, and I'm trying to be patient listener to give you as much time as possible. So, on the same premise, this is my turn now to speak to you, and it's your turn to be a silent listener. But I will not test your patience, because the President Saab and the Secretary Saab and other Zubair Saab and Bhatt Saab also, they have been arguing a case before a divisional bench of NAB, which halfway was to be, stopped because of the present function, since it was my prior commitment to you to come to your function, attend and say a few words for a short time. I think when I entered the hall, Mr. Bhatt Saab was, I think, giving very informative knowledge to you, imparting very important knowledge to you. And as I always have been, very much convinced about his legal acumen and his legal knowledge and his capacity, tremendous capability to apply the legal knowledge to the facts and then to make it a convincing point before the court. I think he has rightly pointed out the one question which was asked by Mr. Zubair and also by you good self, that whether NAB has no jurisdiction in the matters where the scam is related to a value less than 100 million, or where there are less than 50 claimants in a scam. I think that has been very rightly explained, and as the Supreme Court also held, that it is not a jurisdictional determining factor. It will give the priority to the NAB, since if you see the preamble of the NAB, it was promulgated in order to bring back the looted money from the plunderers, from the corrupt people, and to eradicate the corruption. So it was supposed to be acting against the big scams in which the people of this country have greatly suffered. So it is a matter of priority. And it was also pointed out that if there is a special permission by the chairman NAB, even then those scams can be probed into, can also be investigated. And another question, very pertinent one, that whether the NAB laws, particularly NO 1999, is a deviation from the settled principle of law that an accused is presumed to be innocent until proved otherwise. In Asfandyar Wali's case, it has been rightly explained, which has been consistently followed by the Supreme Court as well, while holding that it is not a deviation from the settled principle of criminal justice, but in certain situations, the initial burden, onus, if it is shifted from prosecution to defense, then it will be upon the defense to prove that the defense is not guilty of the offense. Yet there are judgments which I have already dealt with in other cases while deciding the appeals in the year 2016 and 15 also, in which we in the divisional bench have consistently held that there has to be a nexus with the gaining with illegal gains, either to the person himself or to another person. And by itself, by having a lot of money, doesn't itself make it unjustifiable stance so as to convict a person under the NAB laws. Well, gentlemen, ladies and gentlemen, you all know that the accountability is a very much inbuilt quality of human beings. Every limbs of human beings and every thought of human beings is accountable. We have a religious perspective also, because on the day of judgment, we will be held accountable for our own deeds. The father will not be held accountable for the deed of his son, and vice versa. So, accountability is such an important thing which we cannot ignore. And once we have a consensus on this point, that accountability must be observed in all, then we have to evolve a mechanism under which it should be transparent across the board and above all suspicion, and should be done in a transparent manner. Of course, it's an ongoing process, and different stages do come in which we have to respond according to the requirements of the situation. If we look at the world's best administrative systems, we'll dig out and we'll be able to appreciate one thing which is common in all those systems, and that is because if we have a feeling that after doing a wrongful act or doing some wrong to someone, if we can get free, if we can scot free, and nobody can touch me, then I'll be encouraged to do something more harmonious, more harmful to the other persons and to the society as a whole. So, in my humble opinion, it's a very important aspect which must be appreciated and must be acknowledged at all level. Of course, when we talk about accountability, we expect a prompt accountability. Justice delayed is justice denied. If we have to hold somebody accountable after so many years, when it has created a bad impression in the society, and by following his examples, if other people have been encouraged to indulge into corruption and corrupt practices, then I think, and I believe so, that the purpose is not adequately served. We all have a belief in accountability. We have all belief in ourselves, and we all believe in accountability. If we don't, then we will not be able to call ourselves as human beings, because our own system is developed on the premise of accountability. The accountability, as we have seen in the world all over, is a key for sustainable development and sustainable progress. In all developed countries, first they have developed their own system of justice based on accountability, and then, of course, they have gained their position in the committee of the world. In our context, the accountability through judicial system is very, very important. It depends upon an efficient and credible leadership of the institution. Obviously, the examples are followed from the top. If in any system, if the head of the institution has created examples of accountability, the other members of the institutions are bound to follow it. And if it does not, then it will not give a good taste to the other members of the institution. And accountability, as you know, is within the judicial system, at the district judicial level and at the superior courts level. There is a self-inbuilt accountability system. And there are examples, many examples, which we can easily cite, which may not be available in other systems of this country, which place our institution in a different and distinguished position. It has to be observed indiscriminately and across the board in a more transparent manner. In order to win the confidence of the general public, unless it is made with an effort to convince that there is no pick and choose there is no difference between rich and the poor, powerful and the feeble, then we will be able to say and convince the general public that our institution is the best one. As far as the trial are concerned, it is mandatory that the due process must be provided to the accused. We have seen in so many cases while sitting in the High Court and dealing with the NAB cases that the cases that the trials are pending for a very long time, owing to a number of reasons, including the number of witnesses, the laborious and detailed, voluminous record available with the trial court given by the prosecution for the trial, and of course, owing to the preoccupations of the professional lawyers who are commanding the respect and honor in the fraternity of the bar. Delay on conclusion of the trial has been noticed as a very important factor which has shaken the confidence of the general public in our institution. And as you can witness, that for the last few years, our institution has given extra efforts and taken extra measures to make it more efficient and to come up to the expectation of the general public. But at the same time, this cannot be made possible without the cooperation and the help of the honorable members of the bar. Because as you know, that we are part of one system. We do not exist without the existence of the other. If there's a court, there has to be a lawyer. If there's a lawyer, there must be a court. And if there's a court and a lawyer, there must be a system of argument. And there must be a system of delivering justice through judgments. Now it depends upon us that due to our own conduct and commitment as well as passion, we should make it the most efficient system of this country. In accountability laws, there has been special need for the promulgation of the NAB Ordinance 1999. It was for the legislators who have assessed that the old different laws like Anti-Corruption Establishment Act, Anti-Corruption Establishment Act 1947, and their sub-laws, they did not give the desired results. Therefore, a comprehensive law was drafted in 1999. And if you go through the preamble and object of the Act, you will find that it was a resolve by the legislators to eradicate the society, to eradicate the corruption from the society, and to punish the corrupt elements because it was identified as #1 problem of the society. And ladies and gentlemen, let me say at this point of time, when we have successfully fought our war against terrorism in the country, and we have successfully eradicated it to a great extent. Now the next #2 problem, which has become now #1, is the corruption. Let me assure you one thing, which I can say with great confidence, that if we are able to control this menace, nothing will stop it from progress to become a developed country. Because we have nothing in deficiency. We have the best weathers. We have the hard-working people. We have the human resources at our disposal. We have the family system. We have the respect for each other. We have the honor for each other. We have love for this our country. We have great love for our motherland. We have great respect for our forefathers. We have great honor and we hold them very at high esteem, our creator of this country. And we love our children, and we do have all means to transfer our best possible resources to our coming generation. Let me ask you one question. Are we willing to hand over a misgoverned Pakistan to our succeeding generations? I'm sure we all will say a big no. And if we say big no, let's say big no to corruption. Big no to corruption. Thank you very much.